Welcome to thctrust.org. So I'm trying to get caught up here. This is another advanced video. I did a video about this before. I called it mortgage blueprinting or something to that effect. So pretty much what I have here is my blueprint, I guess you will call it. It's a very advanced blueprint. It contains about 3 or 4 potential remedies to resolve a mortgage situation, and these are things that I have done for myself, or I'm in the process of doing for myself, or that have been prepared to be done should they be necessary. And all of this is based on the knowledge that when you sign a promissory note, you are the maker or the issuer and the authenticating agent and the grantor, beneficial owner, security entitlement holder of that financial asset, with your signature, which is the real deal financial asset is your signature on that commercial paper. So you are the the grantor and all of those other things that I said. That's what this is based off of, and it's further based off of the fact that we now know that there was misrepresentation, fraud, and lack of disclosure in the original transaction, which is the reason why we rescind the mortgage deed or the security deed. See, the security deed is the actual claim against the financial asset, which would be the note. And we entered into that transaction because we were under some type of misrepresentation that we were receiving funds that were secured by capital assets of the bank. And I'm actually happy that I can say that, but you can see by the words that I've chosen that I really went into this and I did the research. So these, this is what we are thinking. For example, we think of, if I was going to give you a loan, I am going to absorb a liability. It's going to be a cost to me to give you that loan. So I have to give you value, and that's what did not happen. That's what you expected, and that's how you entered into the transaction. So the problem is, what you didn't know is what you thought was a loan, which is spelled capital L, lowercase o, lowercase a, lowercase n, which is a noun, which is what we would think of as a word, right? Well, usually when you look at the promissory note and those other mortgage documents, loan, although it connotatively sounds the same, it is spelled capital L, capital O, capital A, capital N, capitis diminutia maxima, which is loss of rights, a prejudicing of a thing. So what's really going on is that all capital statement, or actually it's a term is what it is. So it's a term as opposed to a word. Terms are for contracts. You understand what I'm saying? So they misled you, and they made a false representation. They were intentionally misleading by the subversive usage of linguistics and syntax of language to confuse you into thinking that you had a loan when you really just had terms and conditions in a contract, a real estate contract, which I believe they call real estate investment trusts or REMICs and things of the such. But at the same time, somebody may say, well, that is an investment vehicle where and they're titling your assets that were purchased, or another word for purchase is taken, by a trustee to be held in a trust. Now, some people, look at this predicament and say that's fraud. And I'm not saying that I disagree with you, but what I am saying is we're focused on getting a remedy. So based on the fraud, we rescind our signature from the contract securing an obligation to us and securing an obligation on our financial asset, which is the note. So we rescind that contract, right? We're not still participating in the contract, even though we don't do a rescission on the note, because the note is our financial asset that has been taken wrongfully based off of misrepresentation and lack of disclosure, but it has already been invested. How do we know it's been invested? Because we do QSIP research. So this is one of the things that I incorporate when I'm looking at dealing with a real estate issue. We take the promissory note, we send it to our connection. If you need that, if you've donated and you receive the master file and you're rocking with us, our research from start to beginning and learning with us, then you know who to inquire to about the QSIP research on any security, court cases, notes, and so you know about that. Anyway, we do the QSIP search results on the promissory note, and now we know that that note is it usually comes back some type of real estate investment trust or some type of real estate fund. You will find that out. But the point is, you find out this financial asset, which you simply thought was a promise to repay a loan for funds you received secured by financial assets, capital of some lender or money or something like that. You did not know that the whole thing was funded off of a security and that you unjustly are now stuck in a 15 to 30 year slave contract, basically. I'm paraphrasing. It's not called a slave contract. Mortgage. Under these terms with a security that with the security that you have interest in that can be redeemed, but you don't even know about that because you never got full disclosure. And the crazy thing is a lot of people that was perpetuating this activity, maybe it's not fraud because they didn't know what's going on. A lot of them didn't even know what was going on. So they don't even really, so then you make an attempt to redeem a security that you have a principal interest in for the first time. You might have to educate some people on what goes down. I did another video, which you should go back and check, where I talked about the redemption of the note. Okay, but anyways, to get back on the subject, okay, let's see what we got here. Let me go back real quick. Okay, so yeah, that's what we do. We started with the rescission of signature. Let's look at that real quick. And some of this is repeat, obviously. This rescission of signature, why, it's important because if you ever look at a foreclosure situation and you're in a court, the first thing they're doing is they got to bring a contract, because it's an equity proceeding and all of this, admiralty. They're bringing a contract. They point to the security deed, and then they have some type of assignment off of that. That's their link in to you. This is the contract from which they're operating, but you're the grantor on that contract as you were on the note and all the instruments. You're the only guarantor. You're usually the only signature and all of this. There's nothing that says that trust isn't irrevocable, right? So, but we'll get into all of that later because there may be some different remedies that you have under the security deed, under the trust law that you may or may not be aware of. Some of that information we've put, you will find it in here, such as you will go down here and where I have notice of breach of trust, you will click right here, important indexing documents. There's reconveyance of in here, assignments of trusts, removal and appointment of trustees. There's templates for that, and these templates actually come from state clerk recorder's indexing manual. So this not only gives you the templates, it shows you how they properly index and things like that. I mentioned the significance of doing your FOIA request and doing some research and getting the county clerk's recording and indexing manual. And it's very important. I'm saying it like that really clearly because they have very similar manuals, but if it doesn't say recording and indexing, it's not the one. So anyways, that's where you get your templates and all of that stuff from. But let's see. So again, there's three things going on. There's a loan, there's a note, and then there's a mortgage contract. So pay attention to these three things. Replay this video back because I'm going to drop a lot of information in this video so that you can better understand. So yeah, there's these three things. Now, many of us are familiar with the note because that's how we try to approach the situation. We've been trying to discharge the debt with our bank, and we are dealing with them referencing the note number. Now, when I realized that there's the way that I realized that the loan, the note, and the mortgage are three different things and are treated separate things is because I was, dealing with my father's mortgage, which is a Veterans Affairs guarantee. Now, by the way, people who don't know, the trade name through the trust through which I operate is Sylvester D. Moore. My father being Sylvester Moore. I'm only telling you this information, which I really usually wouldn't give, so it's somewhat confidential, because I really want to share what I'm doing with you so that when you do look at some of these instruments, such as the UCC one, that you don't get confused and think that this is the same person. What I'm figuring out is the best way for you, first, as a secured party, you always have to operate in trust. But the best way to operate in trust is if you have somebody that's real close to you, like a husband, a wife, or a son, or a daughter that is knowledgeable, or even just a real good friend that is knowledgeable, you may want to consider making them the trustee so that they can handle the business for you, the grantor beneficiary. That's how I'm handling this so-called mortgage matter situation, alleged debt for my family member. They're the grantor beneficiary and I'm the trustee. This is a key thing because this is built into the matrix. It's a secret that you don't know about, and it's one of the secrets of why everyone can access your credit and you can't access your own, because you have to access it appropriately through a vessel. The trust is your vessel to do so. So it has to be a trustee doing things for the grantor beneficiary, you being the grantor beneficiary, just to keep things simple. So you can be, quote unquote, your own trustee. Let's go back to the UCC here so you can better see what I'm talking about. This is a trust registration statement. Where do I get this from? Well, if you have the master file, well, we're not going to worry about that right now. But if you have the master file, or you can, let's just find it real quick, because this is so important that I'm going to keep questions and answers about trust, FS form. Google that right there and see this document right here. Let's go ahead and click it and look at it real quick. I keep bringing this up in so many videos. Everybody should understand it by now. These are trust registration statements. 10th National Bank trustee under agreement with Paul E. White, dated whatever. Notice that even if this was a revocable or irrevocable trust, it doesn't say that, right? None of these trust registration statements say revocable or irrevocable trust. And these trust registration statements are how the commercial world identifies secured parties on accounts and things like that. So what I'm saying is, even if you're operating from a living trust, a family trust, when you syntax it on your secured party line and you use a trust registration statement, you don't have to identify it as being a family trust or a living trust, and you really don't want to. You only want to give them the public as little information as possible, but you still want to be in compliance so that your documents don't get rejected as you navigate through the seas of commerce. You understand what I'm saying? So that's where this trust registration statement comes from. The social security or tax ID number doesn't go here. Why? Because under the UCC form instructions, they ask you to omit that, so it does not go there. And again, for those who are following the master file and the blueprint, and by the way, I thank you for making the $150 donation. For those who have been doing so, I know I have not slacked off at all. As y'all see, I have been researching, but I've been on hold putting the final touches on this right here, and now I'm about to go right back into the master file and really tighten it up. So if you have not made the $150 donation for the master file, you should do so now, because it's going up to $200 at least. And it's necessary because of the amount of in-depth research that we're putting in it. It's definitely worth $5,000. it's probably worth $2,500 if somebody were going to do it for you, but $5,000 because now you're going to be forced to get the education to use along with the structures that we're putting in place. But anyways, to get back on the subject, you've seen the trust registration statements, you know where to get them from. What are you really telling the commercial world? You're telling them who the trustee is and whether it's under declaration or under agreement or under a will, and who the grantor party is, and the date of that instrument, agreement, will, declaration, or whatever it is. And those are the critical, essential things that they need. Everything else is private and confidential and on a need-to-know basis. So, that being said, understanding this is your ID for your trust, basically. So anything, any asset, title, financing statement that you need to address your name, now that you're operating in trust, this is how you'll do it with the registration statement. Okay? Wrap your head around that. Go through the reference material. If you want all this stuff in one place, make the $150 donation to thctrust.org for the master file. If you want to know how to do that, email me, coaching@thctrust.org. Okay, so now again, so in this, and by looking at this, you can kind of get more insight into secured party creditor too. Yes, I just used the trade name here. I could have put it up here as an organization. The thing is, this is the debtor name, and the trust is now the secured party. The debtor is the grantor beneficiary, right? So, so now, you can do this UCC, and because the trust is a private instrument, many people are thinking, but do I have to have my trust done first? Yes, technically, but your trust doesn't have to be written. For example, this says Sylvester D. Moore, trustee under agreement. Agreement could be express, it could be verbal, doesn't necessarily have to be written, right? So I think the safest, because if you say under declaration, then that's going to be, there's a declaration of trust, and it's going to have a certain date, and that document must exist. You understand what I'm saying? So do you actually have to have a piece of paper trust registered or even in existence before you become a secured party or make a record of it? No. Is it a best practice to? Yes. I think the best type of trust to do something simple and effective, such as this right here, which could be a living trust. Don't get thrown off just because the trustee is somebody else. It still could be a living trust, right? But we have our living trust in our secured party master file. That is the type of trust that I'm basically using for this. I've put myself down as the trustee. I think that's the one I'm using. And if not, the trust that I am using for this, because basically the trust that I'm using for this is a basic trust where I'm the trustee who has the power and authority and the obligation to discharge the debts of the grantor beneficiary and to use the assets and the securities and the title of those assets. I'm his executive trustee, executor for his estate to handle that business. So that puts me right into alignment with all the laws of the United States of America, the probate laws and everything else. And it really shifts the whole status in a position that everybody else has to be on my side. You understand what I'm saying? So there is so that's kind of what's going on with that. Anyway, let's see. What else needs to be said about that? We'll just come back to it if necessary. Know where to get the trust registration statements. Okay, so we were saying first thing you do, well, the first thing I did once I found out that, hey, this was not a loan based off of bank capital. They misrepresented to me. They use a fraudulent, they use misleading terms such as all capital letters in the word loan, actually all capital letters in the term loan. I was misled to think it was the word loan that put me in the mind state that I was receiving bank capital, which is just one slight click that puts you in a whole different mind state that results in you being a slave. It's a big thing. Other things were prejudiced. It just hasn't really all sunk in yet. So because of that, we want to release those claims, affidavit of rescission regarding the security deed. So you can put this affidavit of rescission in the county. It's important that it goes in the county because when these attorneys are trying to go into foreclosure, they're first proving that they have a claim registered in the county. That's why they go to that mortgage deed and the assignment to connect them to your mortgage deed. See, it's this assignment that they're using to connect to that asset that's a mortgage deed. So we want to cancel out that asset based off of the fraud, the lack of disclosure, and all those different things. So the affidavit of rescission, it must cross-reference. It must cross-reference the page and the book number or however they index that exact instrument. And I say it's a good idea to name any of the parties who may have been involved in the fraud. Now, this is a very basic cancellation instrument, right? Very basic, but you want to probably Google what are the terms of fraud, forgery, misrepresentation, which is willful, false representations, and all of those things. I'm going to show you in the notes where some of that stuff is. You want to make sure that you specify the terms, the misrepresentations that occur. For example, a big one that I told you, the usage of all capital letters that are terms falsely represented as words and misconstruing facts, thinking that you're in a lender type of situation when you're really in an investment trust, which throws off the whole entire thing, prejudice your rights and interests, and it's ongoing because you still don't have any disclosure and you don't know what you are entitled to. For that reason, you cancel out the obligation contract. Now, another thing that I would do with this cancellation, you want to, if you are knowledgeable on that level, do your notary presentment, present it to the servicer, present it to the government, the government, the person that's holding the loan. Remember I was saying there's a difference between the loan, the note, and the mortgage contract. Well, you want to get your loan number so that you can present your records to the government and have them index them in accordance with your loan number. The same way when you're contacting your servicer, you're giving him the note number. So usually I find the loan number by usually we find the loan number by if you get a copy of your promissory note and expect those copies. Inspect all the copies of the promissory note that you can get, because usually they're not going to be recorded in the record. You're going to get them from the attorney. When you do a FOIA request or you ask them for the real estate proof and the documents, they send you a copy of the note. And when you look at the note, pay attention to the numbers on there. You know your loan number, usually, and you'll probably see it on there. But if you see a other number, not necessarily the MIN number, I have to do a little bit more research on what that is. But there is usually another number on there, and it might say something index, treasury index, whatever words you see on there. It is very important that you Google those words. See what website, what government website it takes you to. It might be a FHA website or a rural development website, Fannie Mae website, and then try calling that website and inquiring about a loan number. Say that you're whoever. You can say you're an attorney or whatever. Ask a question that they generally may give you. Inquire about that loan number just to kind of test the waters and figure out and convince or prove to yourself that, wait a second, I've been addressing this whole mortgage situation dealing with a servicer, and I didn't quite realize that the holder of the loan is some government office. Now, what my research shows me is that the same person who holds the insurance for the note, which is what the servicer is trying to foreclose and collect upon, in addition to what he's doing in the court, I actually find that they're contacting the government, showing the government their records of your default, which is the letters and things that they sent to you, so that they can not only collect on the note, but that they can get the approval for the government to conduct the foreclosure on the real property so that they can give the property back over to the government. So what I am saying is, this is very important, what I'm about to say now, is that the servicer is an agent for the government, not for you. However, the government is your trustee and your fiduciary, and the government is basically an agent for, well, let's not say they're the agent for you. But the thing is, what I am saying is a lot of the obligations that the banks are not going to honor are direct obligations. for the federal government, and the federal government tends to try to keep you one arm away from them, and that's why they use principles like a servicing industry, right? Because that principle can serve a contract and totally ignore what your rights are because they're not obligated to you. So a lot of times when you start hitting them with these federal statutes and you know your positions and you understand what has transpired in the current transaction, the government is going to try to run from you. They don't really want to talk to you about this mortgage stuff. So that's why I'm saying when you research these numbers, and I'm telling you, you're going to understand by the end of this why I'm telling you to go research those numbers. Like understand what your loan number is and where it's being indexed in the federal government, because once you understand that, you know when you're dealing with the bank, they have banking laws and certain things that they want to follow. When you're dealing with the government, they have the Code of Federal Regulations, and that's what they follow. The banks follow codes. And so what I've done is I started looking for who insures all of these notes, because I already found that these servicers are going behind the scenes, going to the insurance company, getting the okay to even do what they do in a court when they foreclose against you. But you usually would not know this. I found this stuff out because of my diligence, doing things like FOIA requests, like paying attention to all the documents they send, seeing who they sent it to, looking for little email addresses, and sending FOIA requests about everything that I don't know about, addressing who I am and why I'm entitled to the information, and sending a FOIA request and reviewing the stuff that they sent me. So I kind of been putting the pieces of the puzzle together. So that being said, when I was looking into this Code of Federal Regulations and looking for the federal, now why was I looking into federal laws when I realized that, okay, it's the insurance company, the same people who hold the insurance are the same people who hold the loan. And those people who hold the insurance and loan, let's just say they got the insurance and the loan, which is what that includes your original promissory note that you signed, that you thought you was going into a loan, but it was an investment. It went and got indexed somewhere, and that whole thing was a loan. Now let's just say some department in the government is holding the loan. When I started reading the laws as relates to insurance and guaranteed promissory notes, they basically read to suggest that the government is holding the loan and the guaranteed insured portion of the loan, and they got this one account. And what they do is they give it over. They are the ones who are responsible for handing it off over to a servicer in the service-related industry. They do it one way or another, whether they do it directly or whether it's just the operation of what happens after all of these different things occur. They've restructured it to be that way. What you will find out is that the majority, there's promissory notes that are the military people. They get it insured under the Department of Veterans Affairs guarantees, which is still the government. And then you have the conventional loans that were insured all kind of different ways, but those insurance policies are being bought out by the Department of Agriculture. I believe it's Rural Development, which I believe falls under the Department of Agriculture. And they're buying out all of those private contracts. They're forcing some failing companies and insurance organizations to sell to them, and they're offering to buy. For even if me and you did a private transaction and I had a promissory note, they're offering to buy. So you're basically seeing that the government is holding all the guarantee money and the loan, and they're handing the stuff off to the servicer, putting the servicer as a roadblock between you and them. And what I'm trying to get you to see is how this whole thing is working, so that you can understand that a lot of the federal remedies that we know about because of the federal statutes are large, like the discharge and debt remedies, calling for redemption of the note and the securities. These are direct federal obligations. So find out which organizations like the HUDs and the Fannie Mae's, and maybe those financial officers and directors are who you should be directing your processes toward, right? And then at the end of this, I'm going to mention a very important thing about fraud and forgery. So in one case, that's why I told you, let's look at the blueprint again. Well, let me slide this out the way. So the blueprint, we have a bunch of different things going on, a bunch of different remedies in here. Some deal with the discharging debt. For example, here's a discharge process with the CFO. Here's a discharge process with the Treasury Direct. But some of these other remedies may not go with the discharging. It may go with the voiding out of any type of foreclosure or forfeiture of any servicer's right based off of fraud, forgery, misrepresentation, and everything else. So I found in the federal laws where the holders of the loan, who is that? The governments, the holders of the loan and the guarantee will forfeit a servicer's right to collect or receive any type of entitlement, interest, or whatever if that servicer is involved in forgery or fraud in any capacity, an agent to it or whatever. Now, we all know that, but there's only one way to prove that. You have to have them in default to an affidavit. That's the only way to get the positive proof that's necessary to say they are participating in fraud. Because if you can get the positive proof indexed in the appropriate government record to the same government record of the people that have to approve them to foreclose, it's within their government record where a forfeiture says that if that servicer, these is under 38 CFR, that's where the VA side is, and then it's written somewhere else under the conventional loan side. I'll show you those laws later, but it's basically saying if these servicers are involved in fraud, they forfeit their right to collect, and that's another way to stop a foreclosure. Now, I know somebody is probably thinking, well, we know they're involved in fraud. They ignore my paperwork. They ignore that paperwork, and it doesn't really matter. You know, the courts ignore it and all of this. So what I'm going to show you, what I found is I think there's a whole different approach where you can get results. There's a couple of just things that you have to know that you probably didn't know before, and we're going to get to that when we get to it. So, know that. So yeah, we'll get to that. So remember, so let's get back here. Starting out, now we understand why we start with the rescission, right? Because we thought we were getting a loan, we didn't know it was an investment contract, our rights was prejudiced, so we do an affidavit of rescission, we record it in the county, the same county where the security deed is, and we cancel it out by page and book number to invalidate and nullify that instrument so that if an attorney tries to come in, because the first thing he has to do when you go into one of these equity proceedings, he has to have a contract in his hand, a valid contract. So now you can start challenging the fact that his contract is not valid because you have an affidavit that has remained unchallenged on the record and he has been served actual and constructive notice. So now you have to know something about administrative procedure and notary presentment. I'm basically trying to express the importance of having the affidavit recorded on a record, the same record, and canceling out that instrument and letting it cure unchallenged. How are you going to let it cure unchallenged? Well, first off, you have to be very specific, lay out the fraud as best as you can. And this is very basic, right? This is basically says that a affiant was misled, deceived, and induced to sign said deed by the false representation of the grantee, Mortgage Investors Corporation, who prepared the deed and who prepared the now rescinded mortgage deed. The deed is null, void, ab initio, blah, blah, blah. This is a very basic and cookie cutter affidavit. Your affidavit of rescission should be more thorough and complete and present more challenges, truthful statements that are challenges for anyone to rebut. So it should be clear and easily understood on its face, right? Now, so this is just the one that you see here, the affidavit of rescission, and I already did this a long time ago. But moving forward, if you are going to do an affidavit of rescission, I encourage you to go in here and come down here to this right here in 6 where it says Affidavit of Fraud. I cannot click on this because this was given to me in confidence of one of my members. I am allowed to put it here, but I can't really bring it up here. This is a code affidavit. It's going to cover everything you need to say about you not being aware of the underlying trust transaction and the investments and the financial undertakings and the false representations, misrepresentations. And it's going to be such a code affidavit that no fiscal agent, CFO, employee, or nobody is going to stand in your way and deny that. They're either going to be educated and learn by the truth, but they're not going to interfere in facts. You know, they're not going to interfere in a statement of facts that's backed up by federal statutes of large. So this is your actual judgment that will serve as all the evidence you need to rescind and cancel out your mortgage deed and all that, if you want to do, or you need to do an administrative procedure first. This is going to be all the proof that you need to establish the things in the record. Now remember, I told you before that where fraud and forgery are involved in any of the instruments, then servicers, under the federal laws, they forfeit their rights to collect or claim or participate altogether, even if they're an agent to it. So let's go ahead and click on this since we're talking about it. All right, this document is very difficult to find. It's being hidden, which is why usually everything is a PDF, but this is actually a Word document. This is a Treasury form. It's an OMB form. OMB form 1530-0040. It's an Affidavit of Forgery. Now the interesting thing about this form is it requires a medallion stamp. Now if you understand what a medallion stamp is, it's a signature guarantee. And if you understand what a signature is the collateral for all the commercial paper and the money. So this is basically a guarantee, and it's reinsurance of a security of funds. So basically, if you're claiming a loss based off a forged security on here, your loss is being indemnified right here on this form, and or any other person sustaining a loss. So basically, and another thing about OMB forms that many people have to understand, that I'm beginning to understand, is a lot of times there's remedies right within OMB forms, because behind the scenes this obligates certain custodians and government persons to respond under the Paperwork Reduction Act and the OMB office, which is one of the highest offices of government that we're starting to learn. So the thing is, remember we talked about what do? We do the QSIP search results on the promissory note, so we know it's being traded, we know it's a security, we know we're the maker, we know it's our original issue, and we know that a security deed is being secured against it with all the false representations and all this other stuff. We want to cancel it out. Oh, something else I forgot to say. In conjunction with the cancellation of a mortgage deed, you may want to consider issuing a 1099-C recipient copy to adjust the books and records of all parties involved. That's just something else that I want to throw out there. Now, a lot of people, when they hear the term forgery, they think in terms of somebody signing their name. I suggest you go into the Bouvier's Law Dictionary. Let's go. Let's just find it real quickly here. So, I didn't spell it right. So we're going to go to Bouvier's Law Dictionary. You can find out that it's right here online. And we're going to go to F so we can try to find the definition of forgery, because I want to show you something here. Okay, here we go. So we already see forgery is to falsify, to prove a thing to be false. I just want you to hear, it doesn't necessarily say something about somebody signing your signature on a document, right? Trust me, we've been manipulated on so many different levels. Why is this form being hidden? The Affidavit of Forgery. Every other OMB form I find is usually a PDF. This one is a Word document. It's FS form, which is a Fiscal Services form, agent for the Treasury 0974. OMB form 1530-0040. I found this form while doing some research through the federal statutes at large. Anyway, back to the Bouvier's Law Dictionary. Forgery is, let's see, but let's look up the definition of forgery. Okay, here it is. You need to go here and read the definition of forgery. I'm not going to go through the whole thing, but I want to show you something. Let's see where it's at in here. Okay, so out of all of these definitions for forgery, notice there's a lot of them. But this is the one that I want you to pay attention to. And there's other ones that you have to pay attention to, but I don't want to go through the whole thing. The fraudulent application of a true signature to a false instrument for which it is not intended, or vice versa, will also be a forgery. You understand that? So a true signature on a false instrument for purposes for which it is not intended. For example, you're sending a promise to pay because you're under the assumption that you're getting a loan under the common English that you're used to speaking, when in reality that instrument was intended to create an investment opportunity so that custodians and intermediaries can make money off your property forever, and never even that you would never even know about it, so that you can never benefit or receive that beneficial interest. So that's the fraudulent application of a true signature, because you probably did sign something to a false instrument for which it was not intended. That's within the definition of forgery. So between, oh, excuse me, I didn't want to do that. So anyways, between the that affidavit of fraud that I pointed you to, and this affidavit of forgery, which is an OMB form where you can specifically identify the security. You can put the QSIP number on there if you went and got that research, and you can walk into your bank and get a signature guarantee. And this is why I was telling you this is an OMB form. Information furnishers have to respond to this, and you have this medallion stamp on here. Now, let's go in. Now we can go into this right here, but I'll just tell you that I have all the laws. I have the laws at the bottom of here. You can start. Are they on here? If not, I have them in a different. No. So look for them on thctrust.org. If you need to see those laws, contact me personally if you can't find them. I don't think I put them here yet, but I put all the statutes and codes that deal with the medallion stamp signature guarantee and what the recipient is supposed to do for the presenter when they receive that. So they put that on their OMB form, which is an affidavit of fraud, which they have to intake. And in the federal regulations, which is what I have down here below here, is where it speaks of a servicer forfeiting their rights and interests if they're involved with fraud in any capacity or forgery. For example, what you're looking at under here under 38 USC 3712, this is actually, and this is also under the CFR, but this is actually VA guaranteed, which is another form of government guaranteed loan. But I wanted to show you right here, they say, accordingly, unless there shall be, it says, accordingly, there shall be no guarantee liability in respect to any loan as to which a signature to the note, mortgage, or other instrument is a forgery. We just seen what all those what the definitions of forgery is, right? Except as to the holder who acquired the loan and the instrument before maturity, etc., etc. But they go on to talk about even then, as long as he was not an agent, an agent, that means an accomplice too also, he hadn't participated in the fraud or misrepresentation, willful or material misrepresentation of the fraud of the lender and all of that. Notice these terms that they're using. Material misrepresentation, fraud, willful and material misrepresentation. These are the specific things that, if done, disqualify the servicer from getting the green light and participating, collecting on the insurance money and the loan money for the note and the mortgage contract that they are holding. So you have to affect, so this is the government, find out where they're holding it, and this OMB form, it's a government form. Where's it at here? I chopped it down. So the OMB forms are government forms. So send them and put them behind a UCC. I did. Well, no. I mean, that's what I would do. Let me put it that way. Why would I put it behind a UCC? Because you are putting a certificate of guarantee on your signature. You're creating a negotiable instrument, and you want to make sure that this time, unlike last time when you didn't register it and they just took it and didn't give you nothing for it, you want to make sure that you register this, right? If you want to do it that way. But here's something else that I was saying that I wanted to expound on. All those key terms that they were using, willful misrepresentation and all these things, those key terms are important. When you're dealing with fraud and forgery, and remember, you have to set them up with a bit of an administrative procedure on these things first. This is where the things put in your affidavit matter. This is an affidavit here. Let's click it real quick. So this affidavit lays out the whole criteria of what you didn't know. And then it has the terms of response. So this is your whole administrative procedure laid out. We're going to leave it at that. Now, there's something else I wanted to mention. Remember, we just looked at that OMB form, Affidavit of Forgery, and we looked at the definition of what forgery is. Okay, let me go down here and show you something else too real quick. Remember, so this is what I was just showing you right here, where it says, there shall be no guarantee liability in respect to any loan which the signature, the note, mortgage, or any other security instrument is a forgery. This is what the federal government, loan holders, Veterans Affairs, and rural development or urban development, whatever they call it, Department of Agriculture, this is what they're writing to servicers in regard to the instructions that the servicers need to know when they're presenting this paperwork to collect and foreclose and kick you out of your house. So although this is a VA one, now we're going to go down here and see what they say about conventional loans. They say the same thing about conventional loans. Let's see. It might be under here. I put all these links here. You can go read them. Let's see. Okay, here it is. Now we're talking about conventional loans. This is under 12 USC 1715, enforcement of insurance requirements. And this is where it says, if fraud or misrepresentation was involved in connection with the origination, the secretary may require the mortgagee approved under this section to indemnify the secretary for the loss, regardless of when an insurance claim is paid. Okay, that's not what I was looking for, but it's in here also. And then you got right into Title 18, he who falsifies conceals. But yes, it's also in here somewhere else. Where is it at? I think I put it up here. Let's see. Anyways, I put a lot of references in here, links. You can read this stuff, but so the key is, let's go back up here. I'm going to close this out too. This is getting long, so we can do other videos later. But I'm going to show you something. Actually, we'll go one more place. We'll go into something else real deep. We'll look at this CFO discharge process, okay? And we'll kind of base that with everything we did right there. So we looked at, that was kind of a different thing that you could do if you know, that's some, that's one thing. But now let's get to the CFO discharge process. Where we started, it said